Okay. So, I don't have your phone. So they're really glad with everything you're doing.
Okay.
So he said that obviously that we don't have the discovery yet.
All right.
So we won't get that. My recommendation would be that we waive the hearing down today because he is willing to drop it down.
Oh, no, I'm taking the preliminary hearing.
Then he's not going to drop the felony.
Okay.
I would recommend against that. Because we're still going to get what's called a 541 agreement, meaning we can have our preliminary hearing after we get the discovery. I don't think you want
So I'll wait till after that then. I'll wait till we have our preliminary hearing to my right to due process.
But, okay. I mean, it's your call, but right now they're agreeing to withdraw the felony charge.
For what? What is the agreement?
If you waive your hearing today,
okay,
then they'll withdraw the felony.
To what? There are 2 felonies.
No, there's not.
There's 2 felonies in my charges.
No, there's not. There's a felony 1 and a misdemeanor 1.
Not in the paperwork that I have.
In the paperwork I have.
Could I see it?
Yeah, I'll be right back.
Thanks.
Felony 1 and a misdemeanor 1.
Okay.
So I said, right now they're willing to look at all the evidence and everything, but he said right now he'd be willing to make a deal for the M1 and drop the felony if we waive the hearing, but you get what's called a 541 agreement. So that says, even though you didn't have your preliminary hearing, you're not waiving your rights to your preliminary hearing, so we can still have a habeas hearing down at the courthouse after we get all the
no, I want my preliminary hearing.
Then you're not going to get the deal to waive the felony. Like, as your attorney, I think that's a bad idea.
Okay.
Because we have the right to still have the hearing later once we have everything that the cops have. Right now we don't have anything, so you're not losing anything.
Well, I want to see the evidence against me. That's why I'm here.
They're not going to provide any evidence against you other than reading this. They don't have to do anything today.
People have to testify. They have to show evidence.
Testify?
I don't know. There's people that were there. They saw.
All they have to do is show that there may have been a crime and you may have been the one to commit the crime. And some hearsay is permissible at a preliminary hearing. So at the next hearing, the one that we're securing our rights to have today, they have to bring everybody in. At this, they don't. The levels of proof are different at a preliminary hearing. So all they have to do is have an officer come and say they were called to a 911 about a male wearing that and waving a gun around, and then the officer made contact with you and you were in possession of a firearm. That's all they need to say to the judge today, and these charges are coming in. So my suggestion and recommendation as your attorney is to procure the deal to drop the felony and then the 541 agreement.
Yeah, this is not how this works.
It is how it works. I'm the attorney. I know how this works.
Okay.
So
Well,
my
I
best
know.
advice
See, my
is,
thing is, the last time I got a misdemeanor, they sentenced me to 5 years upstate in prison. So,
well, I don't know anything about that.
yeah, I want my preliminary hearing. That's why I'm here. I was supposed to be here for a preliminary hearing. That is why I'm here.
Right, and you have your right to a preliminary hearing today. As your attorney, I'm telling you, we have an agreement to drop a felony.
Yeah, but you have to present evidence against me.
All they have to do is present the officer who says he talked to you when you were in possession of a firearm, which he's going to say today.
Apparently, I wasn't in possession of it,
Well,
though.
it says you were.
Okay. They didn't even have the gun on me.
No, not on you, but it was in the bushes near you, which is constructive. I mean, you might win later. I'm saying right now.
Right, I'm willing to go to trial if I have to.
Right, so let's procure the best option to do that, and that's not having a hearing today. The best
No,
option
I want a
to do
preliminary
that is
hearing
get
today.
the
I want it on record as well.
All right, don't listen to me. There is no record.
I
Huh?
guess.
That's what a preliminary hearing is. It's for the record. Yes, it is.
It's not.
Yes,
There
it
is
is.
nobody
Thank
here
you.
taking the record down. There's no transcriptionist.
Well, then we should record it.
Okay.
I don't have
All right, thank you very much.
recorded.
I have
never
my
do.
phone. We can record it on that.
Be right with you, sir.
I want to see the evidence against me.
All they're going to present is an officer.
That's not enough. That's not evidence against me. That's an officer making a statement. No gun was found on me. That's not enough.
It was found near you.
We'll see what the judge has to say. We'll see.
Write the name down. I can't give you over the.
She's telling me this isn't a court of record. They want me to plead a misdemeanor once right now. I don't know. They don't want to have the preliminary hearing. This is not a due process. I do know that. They could give me years. Still give me years. It don't make no sense. She's trying to tell me it's not a court of record. Well, what are we doing here then?
All right, $10.
That's what we're supposed to be, right?
Yes. Mm-hmm.
Okay. And when?
Next month, I think. Let me double check. these the ones you're paying on? John W.?
Yeah,
Okay. Arch Street in Bloomsburg?
yeah.
Okay, alright. I'm showing November, and then it goes to $15. November. We'll do it again. Okay?
Okay,
Alright, thank you.
thank you. They're supposed to be November.
Okay?
What kind of weather I got it
When do you have to come in again? November.
I pay in September, October.
Evidently you were, this paid October's payment. You were ahead.
On my head. Okay, what when we do then? November.
You'll be fine.
Okay, thank you.
Mm-hmm.
Hi, this is Mackenzie. Oh, okay, I'm sorry. 4959449. Okay, all right, sorry about that, thanks. Hi, this is Naya. Hi, Naya, this is Janelle. I'm calling from Columbia County District Attorney's Office. Hey, I'm calling in regard to Justin Bertolo's case that you're supposed to be a witness for today. I just want to let you know, his attorney, the public defender for Columbia County, is requesting a continuance to reschedule it from today's date. So I just wanted to give you a heads up that you do not need to be here this afternoon, and that Officer Schultz will get you a new subpoena once we have a new schedule. Okay? Oh, you're kind of hard to hear, it's breaking up. Yep, now I can hear you. Sure.
Yeah, they want me to waive my preliminary hearing, telling me that a police officer's testimony is the only thing they have to have against me
Okay, give that to the school.
for this to go to the higher levels.
Order to attend.
It's nonsense, it's complete nonsense.
Has to accept it.
They're not ready for it, that's what it
If
is.
they have any problems, tell them to call either Officer Schultz or
Yeah.
the district attorney's office, because you're a witness, okay? And then either Officer Schultz or myself will be able to certify that you were supposed to be here today. Okay, same thing for the next one. Yeah, no, that's totally fine. Now, my question for you, I just tried to call Mackenzie, are you friends with Mackenzie Duran? Okay, perfect. So I tried to call her with a phone number, it looks like what she has written here on her statement, and they told me it was the wrong number, so would you be able to let Mackenzie know for me? Okay,
Yeah, it'll be the same for everybody, so anyone that didn't go to school today, because they were supposed to be here, they just need to give their subpoena, and they use that as the excuse. Okay, you're welcome, thanks so much. All right, bye-bye. Thank you very much, I appreciate it. Hi, is this April? Hey April, this is Janelle calling from Columbia County District Attorney's Office. Hi, I'm just calling to let you know, Dominic was subpoenaed for just some personal information in this master plan. Unfortunately, that's been continued. He does not need to be here this afternoon, and Officer Schultz will be getting in touch with him with a new subpoena for the new date. And then the other thing I wanted to ask, the other boys that were involved in this, does Dominic talk to them on a regular basis? Okay. Okay. Yeah, so he's a victim, just in his, yeah, yeah, so, yeah, basically he's a victim because Justin Bertola, it sounds like, was just making some threatening comments and stuff like that. And then there was the physical altercation, and I don't know that he's a victim of the actual physical altercation, but I know he is with the threatening language. Yeah. Right. Yeah, yeah. So, but yeah, Dominic's role is basically just gonna be to testify to the threatening behavior and or language that was directed. Yep, that's correct, yeah, so it'll be at Judge Connect's office next time as well, but Officer Schultz will just have to get in touch with you guys and you'll get a subpoena in a specific time. Okay, alright, thank you so much. You too, bye-bye. office in the victim witness program.
Time is
Hi, I'm calling you because unfortunately, Justin's public defender has
9:45.
his preliminary hearing.
9:45.
Yeah.
This is supposed to be a 9:15.
Have the hearing here today.
Mine was 9:10.
Nice.
This afternoon, and Officer Schultz will be getting in touch with you guys to let you know, the next meeting time, once it's scheduled into the. No problem. If you have any questions or anything or any issues with the meeting time, feel free to give us a call, okay? Yeah, no problem. Take that. thank you so much, I appreciate it. Okay, all right, take care. Mr. Kelly, I need you to sign this. You really amended it, so it says 111? You should. Alright, so just sit tight and I'll do, oh, and I was supposed to ask you what payment you can make.
Right now, my work phone covers like $20.
And then the more you can pay, the better you can. Dominic, I asked, about the recording, they're fine with it, I can record it on my phone.
Okay.
And then, you know, I can try to have someone transcribe it later. Normally, if we know we're gonna record it ahead of time, we have to like hire a stenographer to come.
Okay.
It's just not done here on a general basis.
I mean, it's an official court, but it's not recorded like it is in the big courthouse.
Oh.
So, they do have their witnesses here, so,
Okay.
okay?
Yes. Now they have witnesses here. She just told me outside there was no witnesses. Ay. No, it doesn't.
Oh, okay. There we go. Okay. Just checking.
Yes.
Okay, so they withdrew the registration, and then they changed the charge to a 3911, which are instead of paying 20 a month, and will start at 30 plus days out. If you fail to do so, it won't make it easy for you. So on the top of here, there is a phone number, just give us a call, and we'll work with you, okay? Ready to do signature there? Alrighty, and you're good to go then.
These are both mine?
Those are both yours.
Okay.
Have a good day.
Take it easy.
Thanks.
For now, well, let me see. And they cause public by making unreasonable noise, just got it from Laurel.
All right.
How much are you doing, bud?
All right.
May I help you, sir?
I'm here for a prelim.
What's the name?
Welch, Robert. Name 1015.
Robert Aaron?
Yep.
All right, I'll let the officer know you're here.
Thank you. What have you been doing?
Working.
Me too. I started my own business.
Good.
So you don't have to walk all the way down here.
Okay, you just called?
Yeah.
Are you entering a plea?
There's no sense in me. I'm just.
If you want a hearing on it, you would plead not guilty.
Yeah, there's no sense in me pleading not guilty to that. 'Cause I already know the regulations of that crap. 'Cause there was other stuff that was said.
You want a payment plan then?
Yeah.
Okay, do you wanna hang on just a second, cause we just got it, we didn't even enter in the system yet.
Alright.
So you just wanna hang on?
I only have a certain amount of time because I have to go to Danville for an appointment. That's what I'm asking.
Okay, well, how much can you do a month?
So I can't do nothing right now. I'm
What can
waiting to
you
get
do
a
a month
job.
then?
Like I have nothing, no income right now. I'm actually trying to be
Well, we need to set some kind of payment plan up.
$5-10 if I
That
can.
has to be approved by the judge,
Okay.
anything under 20.
Okay, is there any way you can see if I can get approved or? We get a kick of that. He's supposed to be in meeting hearings and shit. But you can go see about that. Just get out of jail and they won't, and I can catch a fine. And now they want to know how I get.
You can do 10, that's it.
Okay.
And you can't wait for your payment schedule.
Okay.
You wanna wait?
How long do you think I'll have?
How long can you use payment schedule? It's not even adopted yet.
That's why I just brought it.
I'll put it in.
I saw the car out there. I was like, what? That's him.
Yep.
Told you I'd give you my word.
Hey, I appreciate it.
I'm gonna step outside real quick, alright?
No, I thought it was gonna be like some old guy.
No, I know.
I also got $10 from my wife for just a minute there, so I can make the payment today, the first one.
She's doing it, so it's
Alright.
$10 today. As
What's that? No, not yet. Well, in here, they're doing something else here, so, yeah, come out here. Then back over to you. I think the plan is gotta wait for everyone to go through here, right?
So how's the dog?
Oh, our dog, good. Yeah, that officer's off right now, so, but.
I saw the video, I was like, I wonder where the dog's at.
Yeah, nah, that guy's off today, or at least for day shift here, but dog's good.
We're thinking about getting a white one.
Yeah.
Neighbor just had puppies and asking everybody in the neighborhood that we're close by, hey, you want a free puppy? We'll get the first shots. They're white. There's 2 white ones. There's one of the white ones that have actually looks like it's gonna have like it might be blind.
Mm-hmm.
And one like has like a dark blue color eyes. I was like, oh man. And the actual German Shepherd color too.
Yeah.
We'll have to hold on to this, the judge has to set the fine, he's in hearings right now.
Okay.
This is for your records. And we have a
It's right there, actually.
Is that, you can read it.
272? 268 5275.
If you don't mind, can I just have my witness sit up with the witness stand?
Oh, sure. Okay, would you raise your right hand, please? Do you swear or affirm to tell the truth, whole truth, and nothing but the truth?
Yes.
Grab a seat, please.
Excuse me, this is
I'm
Judge
recording.
Connect. Can I ask you questions before we begin?
Not unless your attorney approves it.
So I don't have a right to ask questions before this begins?
Well, here's the problem. If you ask a question that may contain something that's self-incriminating.
I'm okay with that. I am. I'm okay with that.
Well, I'm not. You should not.
So
say
there-
anything.
You have an attorney to represent you, you should probably follow.
What are the
I understand that, but I'm wondering, do I have a
Yes.
right to a fair and meaningful hearing?
You have an attorney, then you can direct that to her.
That's what we're
You're
doing
the
here.
district judge. Do I have the
Oh,
right?
Thank you. I am.
Yes, sir. Do I have the right to a fair and meaningful hearing?
Okay. Again, you guys take a break and talk, and go over his questions. If you think there are.
She
any-
actually misled me out in the hallway. She
Okay,
informed me this
listen,
isn't a court of record.
If,
No, I did not say that.
She did. She
Well-
said it outside and in the hallway that this is not a court of
It's
record.
not recorded, is what I said.
yeah, I think that's terminology for,
Well, that's why I have these questions. I actually thought of them.
Okay, so I want you guys to take a break, go over there and talk those over. If she doesn't satisfactorily answer them, then perhaps I will address them. But you have counsel.
I understand that. It's just a few questions. They're just a few
You either
questions.
talk to me and we'll go out and discuss them, or you don't get them answered right now.
Oh, so I don't have a right to have these answered right now.
He's
because
saying
you
that
say
you
so?
can talk to me and then we'll discuss
Let's do
them.
that.
Okay.
Thank you.
You're not supposed to directly address the judge.
I'm an American. I have the right to say
But you
whatever I
have
want to
counsel. If
say.
you want to go without counsel, then do that. But you're not supposed
You
to. direct-
misguided me.
No, I didn't.
Yes,
I
you did.
said
You
that
informed me
the-
this isn't a court of
No, I
record.
did not, Dominic. I said that it's not recorded. There's no transcriptionist here to record the hearing, is what I said to you. Not that it's not a court of record, that it's not a recorded hearing. There's a difference. in
Well,
what-
I just have these few questions that I'd like to ask the judge.
Well, what are they?
Do I have the right to a fair and meaningful hearing?
The answer is yes. That's what you're doing here.
I would like him to answer.
You don't get to ask him that.
Do I have the right to due process of law?
That's what this is. You don't get to ask him that. You don't get to
So-
directly address the judge.
Why
if
don't
you have
I?
me? Because you have an attorney.
So I can't ask these few
No,
questions?
you don't get to talk directly to the judge. That's not how it works. The judge hears the evidence.
Okay, let's
He's
go.
not your
Let's
attorney.
continue.
If you want to represent yourself, Dominic, go ahead.
Why?
All right, things resolved?
I'm not satisfied with her answers. I'd like to communicate with you.
I told him he should not be able to directly communicate with the judge, and that
It's just a few questions.
the answers to his questions were yes.
Okay, well, I'm just going to address the court of record. We're technically not a court of record because there's no stenographer here.
Okay.
So if there's a decision that this case goes down to the courthouse in Bloom, which is a court of record, there's no transcript of the testimony that goes, which is why you do have a right to record it on your phone.
Okay.
Which I am
Or you
doing.
could have paid to have a stenographer here, which is not normally what's done at these, but some people do that.
Okay. So may I ask these questions then?
What's your position on this?
I said yes to the questions. He doesn't think that answer's good enough.
Yes, that he should ask me the questions, or you answer them?
She
I
says I'm
answered
not
the
allowed to
question.
talk to you whatsoever.
I said you're not
Well, this is
allowed.
not gonna be a three-way conversation, that's not how.
That's
these are
fine.
conducted.
It's just a few questions, and I'd like to see the evidence against me.
Well, that's something you talk over with your attorney.
So I'm not allowed to ask these questions.
I don't know what the questions are, but I think that if there's an issue at the end of the preliminary hearing, you and your attorney can talk again.
They're simple questions. They're yes or no questions.
I understand, but I'm not compelled to answer things yes or no. Do you understand that? I may give an explanation, but I'm not here.
Do I have
for
the
a
right
yes
to
or no.
due process of law?
Again, I believe your attorney answered that from what she told me. So I'm not sure why you're addressing that to me. You have legal representation here.
Do I have the right to due process of law?
As I answered already, yes.
Okay. Do I have the right to a fair and meaningful hearing?
That's what we're doing here, yes.
Okay. I have the right to record, you stated. Considering that you informed me out in the hallway that this isn't a court of record, does this court have evidence of jurisdiction?
This is a court of jurisdiction. It's not a recorded hearing, as
Yes,
was just
do you have
explained to you.
evidence of court of jurisdiction, or
What-
do you have
what in the
evidence of
world is that?
I
jurisdiction?
don't know what you mean. It's a magistrate judge in which your case is brought in front of, so it's jurisdiction over your case, yes. I don't know what evidence you mean.
Actual evidence that you have the ability to hear this case, and I just want to make sure that I have a fair and meaningful hearing, that the evidence against me is enough that it be bound to the higher courts. That's what I'm looking for.
That's what your preliminary hearing is.
Okay. Do you have evidence that?
They have to present it. You're not letting us get to that part
Okay.
yet.
I'm ready to proceed.
Thank you. Is the Commonwealth prepared to proceed?
You are, Your Honor.
Okay, let me just go back to the complaint. It's Commonwealth versus Dominic Adrian Moss, MAS. Have an address listed as 501 East 6th Street in Berwick Borough, Pennsylvania. Charges filed by Officer Schultz indicating that the date of the allegation is on or about May 29th, 14:30 hours, so approximately 2:30 p.m. in the afternoon. As a result of his investigation, he filed 2 charges. One is possession of firearm prohibited, which is a felony 1, and the other is to make, repair, sell, etc., an offensive weapon, which is a misdemeanor 1. Both of these, I believe I went over in detail at the time of the preliminary hearing with defendant Moss, which was June 7th, 2021. Okay, does anybody have anything preliminarily before we begin, other than the things we just did preliminarily?
No, Your Honor.
I am recording it, Your Honor.
Okay. Audio.
Audio only, yes.
Okay, Commonwealth?
Thank you, Your Honor. Commonwealth will call Sean Schellenberger. Mr. Schellenberger, you've already been sworn in. Could you state your name for the record, please?
Sean Schellenberger.
And
I'm gonna Sean spelled a couple different ways.
Yeah, S-E-A-N.
Oh, I was wrong, okay. S-E-A-N, S-H-E-L-L-E-N-B-E-R-G-E-R?
Yes.
And I'm sorry, the address then?
My current address?
Yes.
Okay, 712 Summer Valley Road, New Ringgold, Pennsylvania.
New Ringgold?
Mm-hmm.
Summer Valley Road, did you say?
Yep.
1 or 2 words?
2 words, New Ringgold's all 1 word.
And the zip code?
17960.
Okay, thank you.
And Mr. Schellenberger, are you employed?
Yes.
By whom are you employed?
Berks County Jail. I'm a correctional officer.
Let me direct your attention to May 29th of this year, and approximately 2:30 in the afternoon. Where were you at that time?
I was at 510 East 6th Street. That's where my the house of my mother and grandmother. My grandmother had recently passed. I was helping my mother pack boxes of my grandmother's effects.
And did you notice something unusual happening around about that time?
Yes, I heard screaming and yelling.
Okay. And what did you do when you heard that?
At first, I thought it might just been the neighbors talking, but as the noise got progressively louder and worse, I looked out the window.
And what did you see when you looked out the window?
Mr. Moss walking around his yard with what appeared to be a shotgun.
And do you see the person you've identified as Mr. Moss and the person you saw that day here in the courtroom today?
Yes.
And can you point him out for us?
Right.
Let the recording reflect that he's pointing to the defendant. And what did Mr. Moss appear to be doing while he was out in the yard?
Screaming, yelling, seemed pretty manic. I wasn't exactly sure what was going on, if it was a mental health episode or not, but yeah, he just was running around screaming, yelling while holding his shotgun. And then I saw him look like he broke it over his knee. And then that's when I saw the ammunition in there. I knew the gun was live.
Okay. And did you have a clear and relatively unobstructed view of Mr. Moss when he was doing this?
Yes.
And approximately how long would you say that you watched Mr. Moss before doing anything else?
I watched for about 5 minutes, wasn't sure what he was gonna do. I got the family dog upstairs because I didn't want the dog to bark, and seeing he was in a manic state, I didn't want him to fire at the house. It was probably about maybe 30 yards maybe or so from my house, so I didn't want any damage done to myself or anyone else.
So is this across 6th Street then?
Yes.
Okay. And after he broke the gun open, obviously exposing the chambers, did he close it back up again?
Yes.
Okay. So after the 5 minutes of watching him, what did you see him do?
Continued going about his state. I called it in, 911, and when the sirens came, I saw him either go to the bushes to either place or throw the gun, and then Officer Schultz arrived on the scene and he got on the ground.
Mr. Moss got on the ground.
Oh yeah, Mr. Moss got on the ground, yeah.
Okay. So did you see Mr. Moss then without the shotgun for at least a short period of time?
Yes.
Okay.
While he was,
After he went to the bushes?
yes.
That's all I have for this witness.
Cross-examine.
Okay. Did you have familiarity with Mr. Moss prior to this incident?
I mean, he lived across the road. I knew the neighbors there. I was living up there for a couple of years, so I knew he lived there.
Did you ever had personal, like, face-to-face contact with him before?
Just waving coming out of the driveway, that was really it.
Okay. Did you know his name before today?
No.
Okay. And the screaming and yelling you heard, it was only him screaming and yelling?
Yes.
And he was in his own on his own property?
Yes.
That you're familiar with that being his property?
I would imagine so, yeah.
Okay. And he never shot the fire gun?
No.
And there was no one else in the vicinity?
No.
Didn't seem pointed at anybody?
No.
And you said you saw him go to the bushes, correct?
Mm.
You didn't see him place the firearm?
No.
Anywhere? Okay. And how close is where your view is to where he was?
I would say maybe about 30 or so yards if I had to make a guesstimate.
And you could see the inside of the firearm?
Yeah, from downstairs, yes, I could. He was facing the other direction when he was yelling, and when he cracked it, I saw the brass. So I saw like the brass color, so I knew that meant that there were 2 rounds in there. I wasn't sure if they were dummy rounds or live rounds, but I knew that means there's ammunition of some sort to assume in the weapon, so you have to assume the weapon's live.
And being a corrections officer, are you familiar with firearms?
Yes.
Do you own any yourself?
Yes.
That type of firearm?
We qualified twice a year, once with a shotgun, once with our service pistols.
And you were not harmed?
No.
And you didn't see anyone else be harmed?
No.
Okay. Any threats made by Mr. Moss?
No.
Nothing further.
No redirect.
Okay, any objection to him being excused?
No, you're right.
No.
So that means if you wanna stay, you can. If you'd like to leave, you're free to leave.
Okay.
Okay.
Thank you.
Thank you.
Thank you. Thank you. Next time we'll call Officer Schultz.
Okay.
Do you swear or affirm to tell the truth, whole truth, and nothing but the truth?
Yes, sir.
Mr. Lynn?
Thank you. Officer Schultz, would you state your name and department affiliation, please?
Brandon Schultz, the Berwick Police Department,
How long have you been a police officer?
since 2007,
And what is your current position in the Berwick Police Department?
patrol officer.
Were you on duty on May 29th of this year?
Yes, I was.
What shift would you have been working that day?
Day shift?
And did you respond to a call to the area of East 6th Street at about 2:30 p.m.?
Yes, I did.
What did you see when you first got there at the scene?
When I arrived on scene, I observed Dominic Moss.
And let
proceed
me
in
stop
front
you
of me.
there. Were you familiar with Mr. Moss prior to that day?
Yes, I was.
Okay, go ahead.
When I arrived on scene, he was in the center of the yard and got down on his knees, and that's when I directed my attention right towards him.
Did Mr. Moss say anything to you at that time, as far as you recall?
No, not at that time. He appeared to be under the influence of alcohol and possible narcotics.
Why do you say that?
Just from the way he was acting, and once I observed a closer, when I got close to him, I could observe the alcohol coming from him at a later date. But when I was approaching him, 2 individuals pulled up in a car. One identified as Michael Slusser, the other one identified as Gail Gray, who appeared to be friends with him at that point. They came up behind him, and Gail, I think it was Gail, I forget which one, bear hugged him. So
refrained from any further incident at that point.
Was that prior to him getting down on the ground?
After. He was already right when I didn't even order him to the ground, he got down on his knees as I exited my patrol car and said, advancing towards him.
Okay, and then the friends came and
Yep.
one of them bear hugged him?
Yes.
Okay. And were you familiar with this being Mr. Moss's residence before that day?
I did not know he lived there at the time. I thought he was still down on Sycamore.
Okay. So, immediately after Mr. Moss, when you had the encounter with Mr. Moss, did you observe anything else in the area of Mr. Moss?
Not at the immediate time. Again, the report was he was walking around with a shotgun or a long gun. After everything was finished and he was detained and my partner arrived on scene, I was directed over towards the area of the bushes, which is at the corner of his residence going in by the front door, and there was a shotgun laying there, yes.
Now, when you say the report came in as a shotgun or a long gun, would that have been what you could receive from the 911 center?
Yes.
And that's not from Mr. Schellenberger directly, is that correct?
Correct.
So, you found what appeared to be a shotgun in the bushes?
Yes.
Okay. And I'm gonna show you what I marked as call exhibit number 1. Can we have first, Your Honor?
Yes.
Thank you.
Yeah, she got changed.
I showed it.
I saw it.
Yep. Okay. And can you tell us what that photograph is?
Yep, that's a picture of the shotgun I retrieved that day, and 2 shotgun shells.
Okay, were those shells inside the chamber of that shotgun when you retrieved it from the bush?
Yes, they were.
And obviously, as a police officer, you're familiar with firearms.
Yes.
By your examination, both there at the scene and then subsequently, when it was taken into evidence, did that shotgun appear to be operational?
Yes.
Did it have a firing pin in it?
Yes, it did.
2 firing pins?
Yes.
Did the ammunition appear to be live ammunition?
Yes, it was.
Did you, did the friends say anything to you?
Objection.
Well, I'll make an offer that, or offer proof that it's not going to be hearsay because it's going to be a statement of intent.
Well, okay, overruled, but subject to you making a motion to strike it depending on how it comes out.
Did the friends make any statements to you about what they were planning to do with regard to Mr. Moss?
Yes, we all came to the conclusion we knew he wasn't in the right state of mind, and they were going to make sure they kept watch on him throughout the evening, and they were going to call a tap line and CMSU to try and get him some type of counseling and some help.
Okay. And was that part of your factor in charging Mr. Moss by summons rather than taking him into your custody and arraigning him that day?
Yes, yeah, at that point, he did nothing wrong besides he was walking around in his own yard.
And at that point, did you have any personal knowledge as to whether or not Mr. Moss was permitted to have a firearm?
At that time, I did not.
Okay. Did you take the shotgun, however?
Yes, I did.
At that point?
Yes.
Okay. Was that for safety among other reasons?
It was for safety, and from my first observation, it appeared to be shorter than legally allowed to have and possess.
Okay. So, and then subsequently, did you, with the assistance of other officers, measure the barrel of the shotgun?
Yes, it did. Myself and Detective Martin measured it, and we have a dowel rod that's already pre-measured for the length, and the measured length on this was 11.75 inches.
Okay. Would that then fall under the prohibited offensive weapon in that it was under 18 inches, I believe?
Yes.
Okay. And then you subsequently then look at Mr. Moss's, so you already had then, according to your mind, reason for a charge, is that correct?
Yes.
Did you subsequently then run Mr. Moss's criminal record?
Yes, it did.
Did you find any prior offenses that would make him ineligible to possess a firearm?
Yes, it did.
And what was that in particular?
I don't recall which exactly it was. The criminal history is there. I know he is convicted felon for burglary, and he had narcotics related arrests as well. Both of those of which I would believe prohibit him from possessing firearms.
Okay. This is just to refresh your recollection. I'm not gonna put this into evidence because of what it has on it, but can I show you? Thank you. May I approach her?
Yes.
Would it refresh your recollection, in particular with regard to the burglary that you mentioned?
Sure.
What the grading of that was and when it was?
Yep, it was on November 25th, 1999. He was convicted of burglary, which is a felony one, which he pled guilty to.
And that would be a prohibiting offense under the statute.
Yes.
That's all I have for this witness.
Thank you. Officer Schultz, did you have any evidence that Mr. Moss himself altered that shotgun?
No, I do not.
And you said that you received a report from 911, is that correct?
Yes.
And was that directly from 911 or from any particular individual?
It was directly from 911. I don't know who the dispatcher was at that point. It should be on my call log.
And is that going to be made available to defense?
Yes, it will.
And you said that the friend showed up after Mr. Moss willingly went to the ground.
When I initially got there on scene, I got out and started directing my attention and approaching Mr. Moss. At that point, two guys pulled up in a car, came from around the backside of him and bear hugged him just to make sure there was no furtherance to that point. So he was already on his knees without being directed when I got there.
Okay. And had you said anything to Mr. Moss at that point?
Just to stay on the ground or get on the ground.
Okay. But he was already
He was
there.
already on the ground.
Okay. And no weapon within his reach?
No.
And you personally didn't see him place the weapon anywhere?
No, I did not.
Nothing further.
No redirect, Your
Okay, let me step down.
Okay, thank you.
Honor. Call rest, Your Honor. We'll move for remission of C1.
C1 is admitted, and is there any testimony from the defense?
No, Your Honor.
Okay, both want to give me a summary of your positions.
Your Honor, we would obviously object to the charges. Mr. Moss was in his own property. He was not found to be in possession of the firearm by the officer, and there's no evidence that he himself altered or changed the weapon in any way. So we would argue that the charges against Mr. Moss should be dismissed.
We have testimony from a witness who is, by his own testimony, familiar with firearms, is a law enforcement officer himself, that Mr. Moss was in possession of a shotgun in plain view in public outside of his residence, and that he put it in the bush, and then testimony from Officer Schultz that he found a shotgun in the bush that was a barrel less than 18 inches, and then subsequently determined that Mr. Moss has a prohibiting offense, so we believe we have a prima facie case for each of the charges.
Okay, well, yeah, I agree with Mr. Lynn. I mean, there's evidence from the witness that he was in possession and put it in the bushes, and that's where Officer Schultz found it. And then the altered part indicates a provision for possessing it. So at this point, I think there's a prima facie case established, and we'll send it down to the court. No bail change, unless the Commonwealth wants to make it. No bail change. So it's held for court.
Thank you, Your Honor.
Yeah, sure. Yeah, I got that.